Welcome to a special edition of South Sound Seniors in association with the Senior Action Network. Here's your host, Eileen Mackenzie Sullivan.
Welcome to South Sound Seniors, a program for and about older adults in our community. You know, every other month we have been hosting the show in partnership with the Senior Action Network, and this is one of the Senior Action Network shows, and we have two attorneys today. So this is Janet McClanahan Moody and Lauren Pitman, who are joining me tonight, and it's really nice to have you ladies. Welcome.
Thank you.
And tonight we're really going to be talking about planning, especially planning for incapacity. What kind of documents, what do I need to have so that my wishes are really done for me if I can't do them? So I'm just thrilled because this is something that can really break your heart when you hear stories about people that haven't done the planning. So it's just really nice that you took the time out of your busy schedules to come and talk about it tonight.
Thank you.
Happy to do that.
Okay. So I'm going to ask Lauren, kind of start out right away, is, you know, kind of what are the goals of doing this kind of planning, Lauren?
So there are a lot of motivations that are considerations in doing estate planning. The most common are planning for family. People always have a strong feeling, I don't want to leave my family without anything in place. I want to protect them. I want to take care of them. People also often consider tax obligations and planning for how they can limit any tax obligations they may have. But the most common reason is, how do I make sure that what I want to have happen, both while I'm alive and once I've passed away, occur when I'm no longer able to express those wishes myself? And that's really the root of all sort of estate planning, is based in the sort of American ideal of autonomy and having the ability and the authority to make your own decisions about yourself. But unfortunately, as incapacity progresses, people are not able to do that anymore. So putting the right tools in place allows them to do that while they're able to, in the event that circumstances arise and they're not.
Okay, so what are, for example, some of those tools that you're talking about?
Well, when you're talking about planning for your own incapacity, there are really two primary documents. The first is a durable power of attorney, and that's a document that you use to appoint another individual to act on your behalf for you. And it can be used for both healthcare and financial decisions. And not all powers of attorney are created equally. When we're talking about incapacity, it's really important that an individual has a durable power of attorney. And having that word durable simply means that the document lasts through incapacity. It doesn't terminate or stop when the individual becomes incapacitated. So that document appoints another person for health and financial decisions to allow them to make those decisions if the principal, or the person who executed the document, is unavailable, unable to make the decisions, or permanently incapacitated, as can be the case in end of life. And it can be used to appoint one or more people to make decisions, and it can cross the board in terms of managing bank accounts, paying bills, signing tax returns, talking with physicians and making healthcare decisions, employing physicians, admitting them to facilities, and consenting to treatment, including withdrawal of life-sustaining treatment. And that brings to the second document a healthcare directive, which is typically, or also known as an advance directive or living will. And that document, I sort of was saying earlier when we were speaking today that the most common sort of phrase that I think we hear as estate planning attorneys is, I do not want to be a vegetable. Mm-hmm. And you know, that's sort of in the legal world meaningless, but you understand what people are saying. They want to be able to live and end their life with dignity. So a healthcare directive is the tool that we use to allow an individual to make their decisions and their wishes about end-of-life decisions, end-of-life treatment, and put those things in place when they're able to do so before that time comes. And it typically addresses artificial nutrition, hydration, respiration, pain medication, and things of that nature that really address quality of life.
Mm-hmm. So when you're trying to pick somebody to be that durable power of attorney or something, do you have any advice for someone if they're really kind of thinking, now who should I ask?
Absolutely. There are a lot of things to consider when appointing a decision maker. The one thing you should not consider is, who is my oldest child? A lot of people, I think, go to that tendency. They think that there's some sort of a rite of passage that goes with being the oldest, and that's really not the most important consideration. Consideration should include proximity. If someone is making emergency healthcare decisions, then you want them to be around. You want them to be available and at the hospital and the medical facilities to make those decisions. You want people who are financially responsible because they are going to have access to your assets. So basic accounting skills, money management skills, those are important. There are also other sort of more subjective factors. Do they have similar religious beliefs with you in that they will make the same kinds of decisions around end of life and quality of life that you may make? Are they simply the type of person who can hold up in times of stress? Can they make a decision and stand by that decision in a time when the family may be in conflict or may be fighting? That's really the kind of person you want to appoint, not necessarily just somebody because they're your oldest child.
Mm-hmm. Yeah. Okay, so what if that's kind of if you're making the decision on your own, what if you're caring for someone? What if they're incapacitated?
Well, I think, again, the power of attorney comes into play. It's really important that if you're caring for a loved one, you have the right legal tools in place to be able to make decisions and assist that person to really help facilitate their care. And that's not always possible for a number of reasons, and I think Janet will be talking a little bit about that. But if you have the opportunity before total incapacity, putting in place a durable power of attorney. If you have a loved one who's incapacitated and it is somebody that you would like to leave assets to under the terms of your will, there's a tool called a special needs trust, and this document comes into play, this tool comes into play in a lot of different ways. But one of them is that you can place a testamentary trust in your will, which simply means a trust in your last will and testament. And you can place this special needs trust, which allows an individual to get access to assets, have assets available for their benefit, but would not affect any eligibility for public assistance. So if you have a loved one who's receiving need-based assistance, food stamps, long-term care Medicaid, any sort of plan or assistance program based on a financial eligibility, this is a really great way to provide them with a legacy of finances and assets available without affecting that eligibility. That tool is also available for young children. People can do that during their life also, but it's often commonly used with spouses and trust for each other or for the benefit of a disabled child.
Mm-hmm. Okay, well, that's a lot of information, a lot of really good information. So, but just to recap, those tools that are really the most important are the durable power of attorney,
the healthcare directive.
And the durable power of attorney can be for financial and for healthcare, or it could be two different people.
Absolutely, and I just want to stress the importance of a durable power of attorney for financial decisions, because the statutes in Washington do provide a hierarchy for decision makers for health care if you do not have a document in place or have appointed somebody, but that is not true with financial powers. So it's, in my opinion, really the most important estate planning document someone can have is the power of attorney for financial decisions. Because typically the law, the statutes of Washington, they protect people and do what most people would want in the absence of the legal tools, but that's one area where the law just leaves a big gap.
Okay, well, we're going to take a break for just a second here because that was a lot of information to absorb, and then we're going to come back and I'm going to have a few questions for you, Janet. Okay, so we'll just be back in a minute, take some deep breath, absorb all that information, and we'll be right back.
In case you hadn't noticed, there's a great energy at work here in the South Sound. It's called SAN, the Senior Action Network, and the name says it all. The collective knowledge, experience, and commitment of dozens of organizations and service providers represents an invaluable resource for older adults and their families. Truly, SAN is there when you need to reach out. Find out more, visit their website, or call us at 586-6181 and get on board as we celebrate live.
Well, welcome back. I hope you were able to take some deep breaths and remember all that good information from Lauren. But the thing that really struck me during our little break is, okay, all that good information, but what happens if somebody doesn't take that good advice that Lauren just gave us and got those documents? You want to try to tackle that one, Janet McClanahan Moody?
Sure, and I just want to reiterate the importance for people to execute a power of attorney. It's just so critically important. It's the document that takes care of you while you're living, and people often worry a great deal about their will. And a will's important, but a power of attorney really affects your quality of life. And so what happens if you don't execute a power of attorney? And there are a couple of instances where the option of guardianship is the only option. When parents have a child who is disabled and then turns 18, they lose the authority to make decisions for their own disabled child without a guardianship.
Wow.
And often they can go along for a while and everything's fine, but they almost always run into the position where they really do need that guardianship. So that's one instance where guardianship is really necessary. Another instance is when a person has not executed a power of attorney, they become incapacitated for whatever reason. They have a stroke, they are stricken with dementia, and it becomes accelerated to a point where they can no longer make decisions. They're in an accident. There's so many
Right.
examples. If they haven't executed a power of attorney and appointed a decision maker, the only thing that can happen is someone needs to file a petition for guardianship so that a decision maker can be established and health decisions can be made and financial decisions can be made.
Right. Okay, well, so what are some of the downsides of guardianship, though?
Well, guardianship is the most restrictive thing that you can do to someone. It causes a loss of rights, and that loss of rights varies with the structure of the guardianship, but you can typically lose the right to marry or divorce, the right to sue or be sued, to enter into a contract, to drive. There are several rights that you can lose, to vote, and it's expensive. It's intrusive and it's expensive. There are fees for a guardian ad litem to perform an investigation. There are attorney's fees involved. There are ongoing fees sometimes when a guardian is established. So it does cost money, and I think the thing that troubles people most about guardianship is that they do lose rights. And when you're talking about your quality of life, control of your life is pretty important to people. And it's quite a loss of control.
Yeah.
And sometimes it's necessary. The upside is that it protects people when they're really, really vulnerable. If they're vulnerable to exploitation, financial exploitation, or mental exploitation, a guardianship can really protect them. So it does have its upsides too.
Sure, right.
And it is an available option so that they can get help.
So how would a process get started for guardianship?
A petition has to be filed in Superior Court, and a petitioner has to either have an attorney prepare the petition or do it themselves. And there are forms available online. Guardianship is very paper intensive. There are all kinds of documents to start the process. A notice has to be prepared informing the person, the alleged incapacitated person, what rights they can lose. And they have to be personally served. They have to be served the petition and that notice that lists the rights. They are also told at that time what rights they can keep and during the process. And they do have the right to be represented by counsel. The guardian ad litem will get an attorney appointed for them if they want one. And they have a right to object to the guardianship. They have a right to a trial on the guardianship where they can even ask that a jury be present at a trial to make that decision.
Oh, wow.
They also have the right to be present at all of the hearings regarding their guardianship. So that process gets into place, and then there is a timeline for the guardian ad litem to make an investigation and obtain a medical report, and then there's a hearing where the judge actually rules on the petition and decides whether a guardianship is appropriate or not.
Wow, so it's really quite a process.
It
Very
is
different
quite
than
a
having your
process.
house in order
Yes, it is.
beforehand. Okay. So can you explain a little bit about the difference between a guardian ad litem, the term you used, and a guardian?
Yes, and people get those two terms confused often. The guardian ad litem is the person who is appointed by the court, who is a neutral third party, who's on a court registry, and is brought in to investigate. So the guardian ad litem is the investigator. And the guardian ad litem looks at the situation, meets the appropriate people, and determines, is a guardianship appropriate here? What should that guardianship look like? How detailed should it be? And who is the best person to serve as the guardian? And they make a written report to the court and make this recommendation. The court doesn't have to adopt that recommendation, but it carries a lot of weight. And the court usually does adopt that recommendation, or sometimes changes it a little bit.
So you mentioned a little bit before that it can be costly with the attorneys and the whole guardianship process. Who pays for that?
Well, that depends on several things. If the alleged incapacitated person has an estate, the guardian ad litem fees are paid from that estate. And the attorney for the petitioner, those fees can also be paid from the estate. If the alleged incapacitated person wants an attorney, those fees are paid from the estate. And then if there's a professional guardian appointed and there are ongoing fees, those are paid from the estate. So when I mentioned before that it's expensive, that's why. The alleged incapacitated person ends up paying for most of it if the petition is granted and the guardianship is established and they do have assets. If they don't have assets, the county will pay at a real reduced rate for the guardian ad litem. And the other fees have to be worked out amongst the parties. But there is a little bit of help there from the county. There's a pilot program in Washington in a few counties that offer, it's a guardianship, it's like legal services for guardianship, and it's great. And we're hoping that in the future it's available to all counties in Washington, because it allows people, low-income people, to access this process.
Right, right.
Yeah.
Okay, so I'm thinking of bring it full circle. So how, if it's desired to avoid a guardianship, because somebody right now has the capacity and thinks, I really don't want to go that way, what do they do?
Well, first and foremost, execute the power of attorney.
Right.
And we have in Washington a statute that allows a person to put in their power of attorney who they would like to be their guardian.
Oh.
And then the court is required to honor that unless someone can show that that person doesn't meet the criteria for a guardian. They're not 18, they're a felon, they're not bondable. It's important that a guardian be bondable. That is really the best thing you can do. And if we can't get any other message across to people, I think our main goal is to tell people, please take the time, do whatever it takes.